you need help with?
Nothing. I just wanted to see if y'all could help me.
What do you want help with?
Huh?
What do you want help with?
I heard somebody outside.
Yeah, we checked your house. We checked your backyard. I walked all the way through all these backyards. We checked your front yard.
We didn't see nobody.
Yeah,
so.
nobody's out here.
You didn't see anybody?
Nope.
Nope.
Oh,
We checked the whole area.
okay.
What took you so long to answer the door?
Oh, I was trying to put on some clothes, sir. I'm sorry. I was trying to get
I got you. All right.
Sorry.
Is there anything else we can do for you?
Huh?
Is there anything else I can do for you?
No, sir.
Okay.
Okay. All right.
You doing all right mentally?
Yes.
Sure?
My medicine and stuff.
All right. Okay.
I love y'all. Thank y'all.
All right. That's not your black car, though. The SUV? Whose is it? You don't know? It's someone just parked.
She called them. That woman in the white robe, opening her door in the middle of the night, she called 911 because she thought someone suspicious was outside her apartment. She was scared. She wanted help. So she did exactly what every public service announcement, every school, every authority figure has ever told you to do. She called the police. That is why those officers were at her door. Not because she was a suspect, not because a crime had been committed, because Sonya Massey was afraid and she trusted the system to protect her. Her name was Sonya Massey. She was 36 years old, a mother, living in Springfield, Illinois, to the 6th of July, 2024, just after midnight. 23 minutes after she opened that door, she was dead. Shot 3 times in the face, in her own kitchen, by one of the officers she let into her home. And the reason we know exactly what happened, the reason there were any consequences at all, is because every second of it was recorded on a body camera. Now let me explain why this case matters legally, and why the constitutional violations here are so clear they are almost impossible to defend. The Fourth Amendment to the United States Constitution protects people in their homes more than anywhere else in American law. The Supreme Court has been consistent about this for over a century. In Payton v. New York, 1980, the court ruled that police cannot cross the threshold of a home without a warrant or voluntary consent. No warrant, no consent, no entry. That is the rule. Sonya gave consent. She opened the door. She let them in willingly. But here is something most people do not know. Consent can be withdrawn at any time. The moment you say leave, the legal basis for their presence in your home can change entirely. Sonya never got that chance, because she was not a suspect. There was no crime, no warrant, no probable cause. The officers were in her home because she invited them. Their entire legal authority to be inside that apartment rested on her cooperation. She was the victim. She was the person they were supposed to be protecting. Watch what happens when they get inside.
It was something that happened earlier.
Okay, perfect. What is your last name? Shouldn't have to think about your last name. You're not in trouble. I just need to text.
Massey.
Huh?
Massey.
You have an ID? That'd make things so much easier. I just driver's license will do, and then I'll get out of your hair.
I want to show y'all my paperwork.
I will look at your paperwork.
What paperwork?
Okay. I got some paperwork.
Well, just get your ID real quick.
Well, let's get your ID first, and then...
One task at a time here.
Okay. Let me
Here, grab your ID for me.
Okay.
Your ID. One task at a time. So let's do an ID, and then you can dig around for your paperwork.
I don't know where my ID is.
You have that stack right there, maybe?
Okay. 1 second.
Check on her.
Let me get this.
We don't need a fire while we're here.
Right. Okay. Let me see.
The officers are inside her home. She is sitting on her couch. She is calm. She is cooperating. There is no weapon. There is no threat. There is a woman in pajamas at 1 a.m. talking to 2 armed deputies she let through her own front door. And then Sonya gets up and walks to her kitchen. She picks up a pot of water that had been sitting on the stove. She says, "I rebuke you in the name of Jesus." A strange thing to say. Sonya had a history of mental illness. She had called 911 before during mental health episodes. She was not behaving like a criminal. She was behaving like someone who was frightened and disoriented and needed help, not a bullet. But Deputy Sean Grayson told her to put the pot down. She did not immediately comply, and so he shot her 3 times in the face. Here is the legal standard that governs every use of force by a police officer in this country. Graham versus Garner, 1989, United States Supreme Court. It is the foundational case on police use of force. Every officer learns it at the academy. Every department builds policy around it. And it sets out a 3-factor test for whether force was objectively reasonable. Factor 1. The severity of the crime at issue. There was no crime. She was the one who called 911. There was nothing criminal happening in that apartment at any point during that encounter. Factor 1 does not support the shooting. Factor 2. Whether the suspect posed an immediate threat to officers or others. Not whether the officer felt scared. Whether a reasonable officer in that situation would have perceived a genuine immediate threat requiring deadly force. A trained officer in body armor with a loaded firearm, standing with a partner, facing an unarmed woman holding a pot several feet away, does not fire 3 shots under those circumstances if they are being objectively reasonable. Fear alone is not enough. It has to be reasonable fear. Factor 2 does not support the shooting. Factor 3, whether the suspect was resisting or fleeing. She was not under arrest. She had never been told she was under arrest. She was not running. She was not fighting. She was standing in her own kitchen. Factor 3 does not support the shooting. 0 out of 3 factors. Under the controlling Supreme Court precedent every officer in this country is trained on, this shooting was not legally justified. Now watch.
Go hurry, get your med kit.
I mean, there's not much we can do.
We can at least try and stop the blood.
Deputy Sean Grayson shot Sonya Massey 3 times in the face, in her own home, in her own kitchen. She did not survive. The second legal standard this shooting violates is Tennessee v. Garner, 1985. Deadly force is only constitutional when the officer has probable cause to believe the suspect poses a significant threat of death or serious physical injury to the officer or to others. Not a possible threat. Not a feared threat. A significant threat of death or serious physical injury. A pot of hot water held by an unarmed woman who is not a suspect, who called 911 herself, who is standing in her own kitchen, does not meet that standard. It does not come close to meeting it. And then there is Deputy Sandberg, the second officer who was standing right there when Grayson fired. He watched it happen in real time. He did nothing to stop it. Courts across the country have recognized a duty to intervene. If an officer witnesses a fellow officer committing a clearly unconstitutional act, they have a legal obligation to stop it. It is not optional. If you see it happening, if you have the ability to prevent it, and you choose to do nothing, you bear legal responsibility for what follows. Sandberg failed that duty completely. Here is the irony I want you to sit with for a moment. The Castle Doctrine is one of the most loudly defended legal principles in this country. A person has the absolute right to use force, including deadly force, to defend themselves inside their own home. Your home is your castle. No duty to retreat. No obligation to back down. That idea is treated like sacred ground in American law. Sonya Massey was in her castle, in her own home, in her own kitchen. She had not attacked anyone. She had not threatened anyone. And the people who violated that castle were the 2 government employees she trusted enough to open her door for. So what happened to Grayson? He was fired. And then something that almost never happens occurred. The Illinois Attorney General filed criminal charges, first-degree murder, aggravated battery with a firearm, official misconduct. He was arrested and booked. He pled not guilty. His defense is that he feared for his life from a pot of hot water. That a trained officer in body armor with a partner beside him was in genuine fear of imminent death from a woman holding a cooking pot. That is the argument being made in a court of law right now. The trial is pending. But charges being filed at all puts this case in a very rare category. Because in the vast majority of officer-involved shootings in this country, no charges are ever filed. The system is designed, through qualified immunity and prosecutorial discretion, to protect officers from criminal accountability. The officer goes on paid administrative leave. Qualified immunity blocks civil suits. The family eventually gets a settlement with no admission of wrongdoing, and the officer, months later, goes back to work at a different department. The only reason Grayson is facing a murder charge is because of that body camera. The footage made denial impossible. It made the decision to charge unavoidable. Without that recording, Sonya Massey is just another statistic. With it, Sean Grayson is a defendant. Sonya Massey was 36 years old. She had a son. She struggled with mental illness and had called 911 before when she needed help. She was not a dangerous person. She was a person in crisis who did everything right. On the 6th of July, 2024, she needed help again. She called, she cooperated, she opened her door, and it cost her her life. If you want to understand your rights in a police encounter, what you can legally say, what you cannot be compelled to do, and exactly how to protect yourself in the moments that actually matter, that information is linked in the description below. Because knowing your rights is not paranoia, and it is not distrust. After watching this video, I think you understand exactly why it matters. Like and subscribe if you want more cases like this one. There are more coming. I will see you in the next one.